Okay. So thank you everybody for coming tonight to our session. It's a hybrid session tonight. So we have our presenter is in the room at the Warren C. Young Center there in Lebanon, and then we're watching virtually. So for those who don't know who I am, my name is Patty Schramm. I'm the Parent Resource Trainer Coordinator for the SALT Talks. And tonight's session, we're going to be talking about, or I have Laura Drake here. She's going to be speaking on the Special Needs Trust. So if those of you have been attending this month so far, we've been talking about what happens, what planning do we have to do for the future? Because the parents, us as parents, we have to plan for today, we have to plan for tomorrow, but then we have to plan for when we're gone, and what happens, with our plans, how do we plan for that day when our child doesn't have us to rely on? So we're looking at guardianship this month. We're looking at supported decision making. Last week we looked at the stable account, and then tonight we're looking at the special needs trust. I did bring along the questions and I had forwarded them to Laura too. She had the questions that kind of triggered a lot of discussion last week with the stable account for those who attended, but we have them there as well. Now, Laura, I'm going to turn it over to you. Do you want them to type their questions in the chat box and I'll just let you know when they come up, or do you want to wait till the end?
Oh, yeah. Let me know as they kind of come up if they're relevant to the things so we don't go too far past them. So
Okay,
you
sounds good.
can interrupt me whenever. It's fine. I've got a thing to follow, so I'm fine.
Yep.
So I know it says that I'm Eddie Adkins, but I'm not. I'm Laura Drake. And but I'll answer to Eddie for the next hour or so. Because even I'm like, what? Okay. Hi, I'm Laura. I'm an attorney in Cincinnati, and I work for Community Fund Ohio. And we can go to the next slide. So we're going to talk about estate planning for individuals with special needs, but and the goal here is we're going to talk about just kind of like Patty said about planning. And so how there are a couple things we're going to talk about. Planning for your own child. So what can you provide for them after you're gone? How can you do that? And then also if your child receives some sort of lump sum, we see this especially with back awards from Social Security, or let's say they're a passenger in a vehicle and there's an accident claim, or if grandma doesn't thinking that they're being great, and they are, that they leave your child $100,000 and like, yay, only that becomes a problem. So we're going to talk about how we deal with intended and unintended money where we can retain Medicaid eligibility. So the next slide is going to tell us that there we go. I work for Community Fund Ohio, or Community Fund. We're a nonprofit. We were originally created by the Cuyahoga County Board of DD, though 80 of the 88 county DD boards financially contributed to the creation of Community Fund. So, and we serve people throughout the entire state of Ohio. The board is made up of individuals from around the state of Ohio, and currently Huntington Bank is our trustee. So Huntington is, I believe, the fourth trustee since 1992. And people like it a lot because they're based in Columbus. All the previous ones, even when it was Fifth Third Bank, everything was getting mailed out of Cleveland. And so it would take forever. Now everything's mailed from Columbus and people love it because it's much faster for everyone. And that's a link to our website, communityfundohio.org, which is going to have a lot of additional information. But to be clear, I will mention Community Fund and how we can help you, but I will also address ways that it doesn't make sense for you. I always try and point this out. Community Fund's okay. We're doing okay financially. And my goal is to explain what's out there for you, explain what are the options. And sometimes Community Fund isn't the best option for you. And I'm happy to tell you that when that's true. All right, so we're going to go on to the next slide. So what the Community Fund's goal, I like it I went through this with a fine-tooth comb to make sure it no longer, our name used to be Community Fund Management Foundation, CFMF, but it was too confusing. And yeah, there, I missed one. So Community Fund, our goal is to enhance the quality of individuals with disabilities, and at the same time, and that's the big thing, is to safeguard their eligibility for benefits. So there are mechanisms that we're going to talk about tonight where you can leave money to people who can have vast sums over the $2,000 limit, but there are limitations on how that money can be spent. And if you do it properly, they get the benefit of the money, they get to use it, it's there for most of their needs for the rest of their life, but they get to keep Medicaid and SSI, or Medicaid and Section 8 housing, or all these other things that they might need to live their life to their best extent, to the best possibilities. And so that's what the community fund's goal is. And that's what special needs trust in general, that's what their goal is. So Patty, in the next slide is perfect. So when we talk about governmental benefits, there are things that are not means tested, which means you can get, so if you think about it, if you go out and you have a job and you work at P&G and you make 6 figures and you've got a retirement plan worth a lot of money, and because you've been there for 30 years and you started when you were 22, because that makes more sense. And then at the age of 52, you're in a severe car accident and you really can't work anymore. You have a brain injury. You also have some physical ailments that make it very hard for you to work. You would apply for SSDI, Social Security Disability Insurance. And they would say, oh, look, you've been paying into SSDI, into Social Security for 30 years. You're not eligible for retirement, but we're going to give you money up to about $2,000 a month or so of Social Security Disability Insurance. And that is to supplement the fact that because of something outside your control, or even if it was in your control, you no longer can work. That money does not care how much, they don't make you pay down your 401k. You get to keep your 401k. You can still have your vacation home in Florida and your home here, and $1 million in your 401k and another $500,000 sitting in brokerage accounts, and you're going to get Social Security Disability Insurance because you paid into it, and now this is the insurance you're getting back. It's in essence, it's like that's its whole purpose. And then after 2 years, you're going to be on Medicare. It's really 18 months, 2 years, but you'll be on Medicare, and that'll be your health insurance. So, these are not means tested benefits. You can have as many assets as you want. Now, if you get income, so my brother gets SSDI, and then sometimes he walks the neighbor's dogs. Well, that money he makes from that, he has to notify Social Security, and then that gets, eventually there's a deduction from his SSDI because of the other money he's earning. Not that much, but that's not that's not means tested income. All right. That's a governmental benefit that doesn't care how much money you have. And so those are not things that we really, if those are the benefits people have, we're not terribly worried about special needs trusts. But we're going to go on to the next slide, because we are much more concerned when we're talking about, we need to go back. When we're talking about Medicaid. Medicaid is a means tested asset, and so is SSI. So remember, SSI is I've never worked, or I've worked not enough qualifying quarters. And so, and because of a disability, either from birth or new, I'm going to get this supplemental security income, which I feel like the max went over this year. That might be off still, of $943, but I'm going to get that SSI. Now, this does matter. To be eligible for SSI, I have to have less than $2,000 in my bank account. That's also true for Medicaid. Medicaid, now, a lot of people think about, and if your child still lives with you, you might still think of Medicaid as health insurance. But to be clear, that's not the big one we're worried about in this world. We're worried about the waivers. Right? We're worried about those waivers that come in and provide day-to-day assistance and caregivers to help provide for your child when you are no longer able to, or even when you are able to. We get the 3 levels of waivers, and you might already be using one for transportation, for a bus that picks up, or a vehicle that comes and transport your child to school or work or something like that, probably to work. That's a Medicaid benefit. And so, and those benefits, they require that your income be below a certain amount. I'm sorry, that your resources be below a certain amount, and that's usually $2,000. So income, if you have too much income, eventually that will get rid of SSI. Now, of course, that's great because if you have that much income, you don't need SSI, right? So you can have somebody, that's a conversation for a different day, but you can have somebody who's getting SSI, who's working and earning money and building up their SSI, building up their income, their qualified quarters of earning income. And maybe eventually they wouldn't need SSI, but maybe would switch over to SSDI. So when we're talking about special needs trusts, we're generally talking about protecting these means tested benefits like Medicaid and SSI. So if you want to go into the next slide, then the thing about these is some people say, oh, well, I have some money, but I've hidden it. I still get people say that not all the time. Well, I'm going to hide it. And I'm like, okay, to be clear, when you fill out the application for Medicaid, it says, where is all your money? And if you don't disclose things like that, then you're committing Medicaid fraud, which is, it's a crime. So it's not a good idea. And also, more importantly, we don't have to do that anymore. There are so many great options out there where you can place money, where the individual with a disability can access it easily and maintain eligibility for Medicaid. So that's what we want to think about. There are other things too. If somebody has more than $2,000 on a regular basis, there are certain things that you can prepay that are allowed, like you can prepay burial accounts, a funeral burial account. Like if you want to be cremated or buried, you can set that up, and that's something that can be built over time. It can exceed the $2,000. Is what I'm saying, because you don't technically own it. There's a lot of things going with that. All right, we're going to go on to the next slide. So when I'm looking at being eligible for Medicaid, Medicaid cares if an asset is something that you can access. Is it accessible? So actually, one of the things that most comes up nowadays is we have individuals who are working at like Kroger or someplace else, and they're building up a 401k. And that's fine. As long as they're working in that job, they could have $300,000 in their 401k, and that is not an accessible asset because, 401ks technically are not accessible as long as you're there. Now, if they quit or are fired, that immediately becomes accessible and it becomes a problem. But until then, it's not accessible. Things that are accessible, though, right away are back payments from Social Security. Now, Social Security will tell you have 9 months to pay that down. Yeah, for SSI purposes. Medicaid doesn't give you the same time frame. Any inheritance that they receive once it's gone through the probate court system, any bank accounts titled in the individual's names, any IRAs. So again, not a 401k. So it's an IRA is someplace where I'm not working, unless it's a simple IRA where I'm still working. A life insurance policy that has cash values or an annuity, which shouldn't come up too much when we're talking about individuals who've been disabled since birth. So all of those things count towards the $2,000 ceiling. What we see with life insurance policies is if there's a cash value, if it's a whole life policy, I'm not out. The $25,000 payout isn't what Medicaid's concerned about. They're concerned with what's the cash value I can take out now. And so that's where we get the 2,000, we can finagle that. We can borrow against it to keep under the 2,000. But these are assets that Medicaid looks at when they're determining whether or not someone is eligible. And they're the assets that oftentimes create problems that result in needing to do a planning with either a special needs trust or sometimes the stable account. All right, so we're going to go on to the next slide. So obviously, your obligation of support ends at the age of 18. You no longer have to provide for them. And it used to be, so my aunt was developmentally disabled. And when my grandparents were doing their estate planning in the 60s and 70s, they died really tragically young in 1972. But when they were doing that, their only option was to disinherit my aunt. That's all they could do. Now, there's still some attorneys who tell you to do that. And if you do meet one of those attorneys, get up, walk out the door. They're horrible people. Just drive me nuts. Not necessarily horrible people, but I really dislike them. I know one who does that, and I'm just like, how can you say that to people? The government will provide for them, and they will provide something, but um, so so actually, Patty, I'm going to tell you something, and I can see stuff popping up on the chat. And so someone just asked me, if someone gets a back award from Social Security, how long do they have to spend it to be down to the $2,000? And I will tell you, as far as Medicaid is concerned, they have until the end of the month in which they receive it. Social Security gives them 9 months before it affects their payments, though if it's SSDI, it would never affect their payments. But if it's SSI, it would. So, but Medicaid says you have until the end of the month in which you receive it. Now, we've pushed past that. We've gone a couple months and they don't do anything. But you don't want to hold that for, you're going to have a problem. Now, if they're on Medicaid, Medicaid's not going to catch it for a while until they do the recertification. But my thing is I don't think you should wait that long. But because technically any month that I end the month with over $2,000 in my accounts, then I'm not eligible for Medicaid that month. So but Medicaid, I had a client who recently, they got $100,000 back award, and for various reasons, it didn't get addressed for about 8 months, and Medicaid didn't do anything about it. So it sat in an account because everyone thought they were going to take, the Social Security was going to take it back. To this day, we actually don't know why the client got this huge back award from Social Security. Seriously, no one has any idea why, but it's been over a year and they've never asked for their $100,000 back. So whatever, we're moving on. So you could disinherit an individual with a disability in a will. You just leave them nothing, but there are better choices. Ohio offers great options, and any money you leave that person is going to enhance their life during their life, the rest of their life. And then if you plan ahead, whatever they get, whatever you leave to them, the remainder can go to the other beneficiaries you want. So your other children, your grandchildren, a relative, or the charity of your choice. Those are all options. So now if you plan ahead, you can provide for your child and create something going forward. All right, the next slide. So when we talk about doing a last will and testament in Ohio, if you're disinheriting a child, you can put a clause in a will saying that. You can also just leave them out. I would talk to your attorney about that. There's various ways of addressing that. You can, in Ohio, you should also list who you would like to be the potential guardians of your child with a disability. And it may be that you're deciding not to get guardianship, and that's fine. I'm not a big believer that guardianship is necessary all the time. But even if you're not getting guardianship, we strongly recommend that in your will, you list your other kids, your typical kids, and family and friends who would be willing to potentially be your child's guardian. And the reason is, especially around here, people move to Indiana and Kentucky, and technically it's harder to be a guardian if you're out of state. I mean, it used to be you couldn't be at all. They've really relaxed that, but they still like to see some sort of connection. And so if you list them, it doesn't mean that they're going to be the guardian. It just, if you've listed them in a will or a power of attorney, then it gives them the right to apply regardless of what state they are residents in. So we recommend that you do that and that you list more rather than fewer people. We had a case where there was a very large family, it was a West Side Cincinnati kind of clan. We had a lot of kids, we had a lot of cousins, and I think we listed like 22 potential guardians' names. I mean, is that necessary? Not really, except they all live, some have gone to Kentucky and some have gone to Indiana. We just wanted to be clear, any of these people could do it and we'd be okay with that. I personally think, now, sometimes not everyone needs to leave an equal share. I had a family who was in a situation where they were very financially secure, and their child with autism, they left a decent amount of money. But even I said, why are you leaving, comparatively speaking, such a small amount of money? And their response was, because of his autism, he was in a facility that he was very comfortable in. He didn't like to go places. This was to buy clothing and things like that. He couldn't handle change very easily. So they saw it as basically dental work and clothes. And so they're like, we don't feel that we need to leave, hundreds of thousands of dollars for dental work and clothes. That's fine. Other people are going to leave an equal share. It's entirely up to you how you want to do that. But you need to remember that if you're planning ahead, then whatever you leave to that child, if it's done properly, can go to your other kids if they don't use it. So that's something that can work. Now, sometimes people say, well, what I'm going to do is I'm going to leave everything. So I have 3 kids and I'm going to disinherit my child with a disability, and I'm going to give my other 2 kids 50%, and they know that they're supposed to provide for this child. Or I'm going to give it all to their one sibling because she's the better sibling and she'll provide for them. And we've had people do that, and I'm going to tell you that that's a horrible, horrible idea. And the example I have that showed why it was a horrible idea was then, mom and dad left everything to the one sibling to care for her disabled sister. And then that child died unexpectedly with minor children. And so everything then went to her minor children. And everyone went to the court and said, yeah, but the thing is, she's really supposed to use a lot of this to provide for her sibling. And the probate court said, not our problem. She has minor children who need to be taken care of, and they're our concern, the court's concern. And so too bad that that's what mom and dad intended to do. They didn't set it up correctly, and now it's all going to these minor children, and there was not a penny left for the disabled aunt. Nothing for her. Also, if that same sibling is in a car accident and is deemed at fault, all these assets that you left for the benefit of your disabled child are now going to this other party, this non-family member who was injured in the car accident. Again, it doesn't matter what your intent is. And then, even if you don't think either of those things are going to happen, though they happen all the time, and you trust your child explicitly, your typical kid explicitly, what I always come back to is, yes, but who are they married to? Who do you trust their spouse? Do you trust that that person isn't going to have some ability to say, hey, I know the money's for your sibling, but we could really use this now and they don't need that. So why don't we use it? And the thing is, if you talk to attorneys who specialize in this, we will all tell you, I don't trust your kid. They will steal from their sibling, whether you think they will or not, they will take from them. And in my family, again, my grandparents, when they passed away in the 70s, they had 3 children. They disinherited my aunt because that's what they had to do. My mother was in her 30s. They gave her half, and they gave my 19-year-old uncle the other half. And I mean, until my aunt passed away a few years ago from cancer, it had been a fight between my mother and her brother. My brother felt that they had spent her third a long, long time ago, and my mother felt they would never have spent her third. And it becomes, if there's not a specific amount of it turns into a disaster, and it does. So I'm very opposed to this. I'm going to leave the money to the other child, to the point that in my practice, if someone says that, I'm like, I'm out. I'm not representing you. I'm not doing that, because your intent is never going to come through. So I won't do it. I don't want to be a part of it. Because I've seen it doesn't work. So now you can give your executor in your will. Some people say, I don't have the money to do a special needs trust. I'm like, okay, then you need to tell your executor in your will, you need to create a wholly discretionary special needs trust for the benefit of my child with a disability. You still need an attorney who knows what they're doing to draft that. And that's a big part of this, is that you need to find an attorney who knows what they're doing. You can always email me and I can give you a list in the counties that do these kinds of trusts. You can also go to NAELA. It's NAELA.org, and it's in the slides later on, to find attorneys who specialize in this kind of stuff. It's important to do that because they need to know what they're writing in there. So your will can address everything. It's not the perfect way, but it is not a bad way. So, all right, let's go on to the next slide. I'm going to take another drink of water. I recommend, most people recommend that if you are going to be, that you do what's called a letter of intent. And that you get used to doing this maybe once a year, every 2 years. You can go on the internet and letter of intent, developmental disability, child. It's a form and you just kind of fill it out. And then over time, you'll see what's missing that you want to change it. And it talks about things that your child likes and doesn't like they love chicken nuggets, but they hate ketchup. They can't sleep well unless they have this blue toy in their room, you know. They, if that blue toy is in their room at the end of the night, they'll never fall asleep. Take it out at night. But what all those kinds of things that you've known over your lifetime of raising this person and living with this person, of their likes and dislikes, and basically it's just a way for you to share that knowledge with the next generation. Or if you're on vacation, someone can help step in and take over. It's a great thing to work on. It doesn't have to be perfect. You don't have to spend days doing it. Like I said, to me, it's one of those things you print, and you start writing it in, and then you start typing, and then you start updating stuff every once in a while. Put it on your calendar. January 1st or January 3rd every year, I'm going to go in and update my letter of intent and see what's still there and what's not. It's just a form that you can have, so that if something happens to you unexpectedly, someone can step in and make for an easier transition. So that's just an idea, and we like to mention that. So we're going to go on to the next slide. But you can Google and find a letter of intent. All right, so now we're going to talk about trusts. So once upon a time, trusts were for the uber wealthy because they were called dynasty trusts, and those kind of went out of favor, though they're coming back now. And but the thing about a trust is that it's actually more flexible than a will. It has a lot more contours to it. It's easier to amend and change. And it's a document that allows you a level of control over your money and your assets after you pass away. That's kind of the purpose of it. So we're going to go on to the next slide. So when we talk about trusts, generally, most people do a testamentary trust, an inter vivos trust. So like if you came to an attorney and you just had your first child, or you have, 2 kids under the age of 5, and you're a young married couple, most attorneys would say, just do a testamentary trust. In the will, it says that if your kids are under 25, when you pass away, they should create a trust. And the theory behind it is that you don't really have that much money because you're young. And so we're going to throw the money into the trust. Really, by the time the kids get raised and go through college, there's not going to be that much left. So they can't blow it. They don't get the bulk of it until they're 20. They don't have control of it at all until they're 25. It can be used for their benefit, but they can't control it. So that's pretty standard. I like to do those with young couples and with young families, because I'm like, you don't know what your kids are yet. You don't know where they are. You don't know what they're going to need. So like, that's a good placeholder. It's very popular to do revocable trusts. That's a way to avoid probate. A revocable living trust is one that is basically an extension of you, and you put your assets in it so that when you pass away, or if you have a stroke, somebody can just step in and start controlling your assets. All right, that's pretty common. That is, and then an irrevocable or irrevocable trust is a Medicaid planning trust, where you're like, oh, I'm getting older. I don't want my house to be sold to pay for Medicaid, so I'm going to sit there and put my money into an irrevocable trust. That's fine, but what you have to understand is you have to give up control of whatever you put in there. So people don't really like those. And then support trusts are just exactly that. They provide like a level of support for somebody. They provide for extras. And then a special needs trust, if you've ever heard of a term of a spendthrift trust, a special needs trust is a form of a spendthrift trust. And what it is usually what we're going to talk about are these. What it means is the beneficiary of the trust has special needs. They cannot control the money, but the money can only be used for their benefit during their lifetime. So we're going to go on to the next slide, which I think is going to get us into more about this. Yeah. So what the whole thing with figuring out a trust The biggest, so remember, it is by definition the word. I trust you, the trustee, the person who's going to be in charge of the money after I die. I trust you to be in charge of the money. So you're going to be the trustee during your lifetime of pretty much all these trusts. And now you got to find somebody who's going to be the trustee afterwards. Some attorneys will tell you, oh, hire me. I, the attorney, will be the successor trustee. I never get that. I never really understand that. I don't actually. I feel like that's weird. I don't understand that, because to me, they're going to be dead by the time you die too, usually. So it's not a great idea. And also, trustees get a fee, and I don't know that necessarily attorneys have that skill. So I wouldn't do that. The more money that's in the trust, or the stranger the trust is, meaning the limitations that you're putting on the trust, the controls you're putting in place, then the more skill and experience you need in a trustee. The craziest things people do that I love, say, listen, will say, who do you want to be your trustee? And they're like, well, I guess I'll name my typical kids. And I'm like, your 5-year-old and 7-year-old children is who you're going to name to be your trustee of your special needs trust. Maybe we should come up with somebody between now and until they're older. Also, until you find out what they're like as adults. Because, I mean, a 5-year-old and a 7-year-old might be great with money, but they might not be when they're 25. So you can name family members, you can name your typical children. But I would always like to point this out, that when you're doing that, and I missed that chat thing, Patty, I didn't see it. So if it's important, we might need to stop, but let me finish this thought. So the thing you need to remember is that when you name your typical kid as the trustee, they are going to get whatever's left in the trust when your child with special needs passes away. So they have a vested interest to not spend money on them. So I'm not crazy about the kids being in the trust. And I have seen many siblings rob their sibling, their special needs sibling blind. And the thing is, there's nothing left. So what are you going to do with it when you finally figure it out? I mean, there's no money. So how do you fix it? So I like professional trustees. I'm very fond of professional trustees. There are banks like Fifth Third Bank or Northside Bank here. I think First Financial also does that, though I haven't had experience with that, where they have dealt with special needs trusts. And then there are pooled trusts like Community Fund and some others that have built-in trustees. So Patty, what was the question? Something I should answer now?
Yeah, how much does it cost to set up a special needs trust?
So when you think about it, it depends what you're kind of doing. So if you're doing, most people are going to set up a special needs trust. It's going to be part of your entire estate plan. You're going to go to an attorney and they're going to do your powers of attorney, your healthcare power of attorney. They're going to do a transfer on death affidavit for your house, your will, a trust, like a revocable living trust, and a special needs trust. And you're looking at probably the low end of that is now probably $2,000 to $2,500, $2,000 to $2,500 for the whole, for a couple. I'm saying for a couple. Some attorneys charge less for one person, some don't. And then I think you're probably looking at a max between 5,000 and 6,000. So it's a very large range. And some of it, I would say, like some of the attorneys that charge less, I mean, like, you get what you pay for. And I don't think they give great advice. They often say, oh, just name your typical kids, but they don't deal in it a lot. And then some of the attorneys just charge insane amounts. There's a guy who charges like $10,000. Why? I don't know. He does, and people pay him. So there you go. So there is an aspect of like, you need to do a little bit of due diligence, but you're probably looking in the $3,000 to $5,000 range. So that's probably a safe area. If you're paying, I think more than 5,000 is a bit much. I think under 3,000, I might question, but I mean, not necessarily. You might run into somebody who doesn't charge that much. So or someone who's newer but they know what they're doing. So, so picking the trustee is the big thing in the trust. And also, for the record, that's also sometimes going to choose the kind of trust you need. If you don't have any family members or friends or connections who you feel comfortable with having the money, you're going to have to go with a professional trustee or a pooled trust. But if you were like, well, we only have $50,000, that's all we're going to be able to leave them. There is no professional trustee that's going to take that. You're going to have to look at a pooled trust, because banks, they they want they want at least a few $100,000 because they're going to take a 2% fee off the principal, every year, and they're not going to do it for for a very small amount of money. Like the big banks, the US banks, they're some of them, they want $500,000 to $1 million, and they're going to take 2% on that. But some of the smaller banks, like a Northside Bank, they would take a lesser amount. So, all right, so we're going to go on to the next slide. So, like I said, I see you as being a trustee of the trust in the beginning. There's no reason you wouldn't stay in that. And then the siblings, I'm not crazy about them. The other thing I always like to point out as a sib, because I have a brother with a disability, and when my parents die, they have not died. When they and don't tell them I say these things about them. When they die, I'm my brother's going to need us to step in and help him, and I get that, but I'm also going to be grieving the loss of my parents, right? And my parents are in their 80s, so I mean, my parents are in their mid 80s, and they're both going strong and living independently. And my mom goes and works out every day, and I mean, I don't see anything happen anytime soon, but I still think I'll be working when they pass away, because I'm going to be working for another 12 to 13 years, which will put my mom in her mid 90s and my dad in his late 90s. There's no way he's making it that long. So, because my mom works out every day, but he doesn't. So, he steams. So, when they pass away, I'm going to be suffering the loss of my parents and working full time, and now be expected to step up and do a lot more day-to-day stuff for my brother, right? Making sure he gets to his doctors, making sure he gets his medicine, making sure things are happening in his life, that everything's running smoothly. And so if you also ask me to be the trustee of his trust, that could be a lot. I will also say that my brother doesn't, I love this. I do love this, for the record, because I'm an attorney and I keep trying to point that out to him. He doesn't trust me. He doesn't, he's afraid, he's very afraid that I'm going to steal all his money. I do know why he's afraid, because I told you about my annoying uncle who I don't like, who was not a good person, and who didn't want to give money to his sister, because they spend it all. He's not a good person, and I have his eyes, and so my brother's very worried that I'm going to steal his money too. And I'm like, okay, I'm not going to steal your money, but okay. And so I would be a horrible trustee for him, because it would freak him out all the time. And I don't want that. I don't want to deal with that, right? So I have no interest in being his trustee. I also know how much time it is, so I don't want to do those things. And I think you have to take that into consideration. If you are really confident that your adult child, typical child, should be the trustee of the special needs trust, they need to understand they need to truly understand what they're agreeing to before you do that. And there are books they can read about that. And if they won't take the time to read those books, they should not be the trustee. Like I said, you can name a bank. There are some that have more disability related knowledge than others, but if you have a professional trustee, they sometimes will be you'll ask them to spend money on something, and if they're not sure, they will hire an attorney to determine whether or not they can spend the money on that. And the trust will pay for that attorney. So that, to me, is one of the great advantages of these pooled trusts. The pooled trust that we're talking about, like Community Fund, there are others, but we like Community Fund, obviously. Their job, all they do is make disbursements out of these trusts. So they know whether or not it's an allowable expense. And if they don't know, they figure it out and they pay for that. They don't charge that to the individual trusts, because the point is, with a pooled trust, is they're presenting themselves as having this knowledge. And so therefore they're expected to treat that accordingly. All right. So those are things to take into consideration when choosing a trustee. We're going to go on to the next slide. So if we're talking about you have money that you want to leave to an individual with special needs, so the assets do not currently belong to the person with special needs, you basically have two trust options: the wholly discretionary trust, which I've alluded to before, and a supplemental services trust. Don't do the supplemental services trust. It sucks. The Medicaid keeps half of whatever you put in there. So we don't like that one. So let's go on to the next slide. Just talk about the whole discretionary trust. I think the next slide is about that. Sorry. Yeah. If okay, and then if the money belongs to the individual with the disability, so again, this is that SSI back award or money they received because they were in a car accident. They have two options. They can have a private Medicaid payback trust, or they can have a pooled Medicaid payback trust. All right. And so you can write a private Medicaid payback trust. I mean, I think they're silly, but you can do them. They do actually offer some benefits, but if you have somebody who's received a large amount of money and they're under the age of 55, and they have, then that might be something to think about. But generally people use the pooled Medicaid payback trust option because they're significantly less expensive to set up and they cost very little to run. All right, let's go on to the next slide. And then if it's not what I think it is, I'm going to come back and talk about something else. Okay, there you go. Yeah, there it is. That's what I was looking at. What is a wholly discretionary trust? I was like, I forgot about that other slide in between. So a wholly discretionary third-party beneficiary trust means that the grantors, the ones funding the trust, are putting their money into it for the benefit of a third party, the child with the disability. These trusts have to be done properly. And the thing that I do a lot is people say, hey, will you look at this trust? And I go, yeah, I'll look at it. And I go, this is a crappy trust. I don't think it's a properly drafted trust. And they say, well, I just spent $2,800 to get the trust. I'm like, well, good for you. It's no good. And so FYI, that's why I'm really important to me that you hire someone who knows what they're doing. And then they'll say, but they knew what they were doing. I'm like, okay, I'm out. You asked my opinion. I told it, I'm out. And this is the thing. Standard trusts say something about, I want to provide for the support, education, maintenance, welfare, standard of care, living, maintenance. These are these words that they use in there. If they say that, if it has any standard of care, support, education, maintenance, welfare, language like that, it's not a valid special needs trust. Because that means the trust has to pay maintenance, that's their living expenses, welfare is their medical expenses. Well, that's what SSI and Medicaid are supposed to pay for. And support, that's also what SSI is supposed to cover. And so the trust is not any good. So that's clear. So there has to be no standard of care. It has to say that the trustee at their sole discretion can spend the money or not on whatever they want. That's important. It has to have what's called a poison pill. And the poison pill says that if Medicaid or Social Security determines that the trust is not a special needs trust, the money is distributed to the next beneficiary. So that's usually your typical kids, but it's not the individual with the developmental disability. They're not going to get anything. So that is good. You need the poison pill. You have to have the poison pill, but you don't want to have to invoke it. What I see a lot of trustees do is they take their trust, not trustees, I see a lot of attorneys do, they take their standard trust and they throw some of this stuff in there, but they still give the beneficiary the right to change the trustee. Well, if they do that, it's not a valid special needs trust. And that's one of the big mistakes I see happening. So that's why it's important to me that when you hire someone to do these, that you make sure they're drafting lots of special needs trusts, so that they know that they're not using something that they're not tweaking an existing document. They have a document for this. The advantage of a wholly discretionary third-party beneficiary trust, where you set this up before you pass away, or you tell your executor to do it upon your death, is there's no payback, which means Medicaid isn't entitled to any of the funds when your child with the special needs passes away. And that's important. All right. Because remember, the other trusts, those Medicaid payback trusts, Medicaid gets paid back. That's the downside, because it was their money. It was your child's money. And so Medicaid allowed them to place their money into a trust and keep Medicaid for now and use it over time. But if they didn't, Medicaid's going to take the money. This is your money. It is never your child's money. It's only going to be used for their benefit during the lifetime. But if they don't use it, it's going to go to your other kids. All right. We're going to go to the next slide. So the Medicaid payback trust, if you use not a pooled one, you hire an attorney to draft it. And the first thing that happens is the beneficiary has to be under 65 when it's created. That's a rule. And then when they pass away, Medicaid is going to get they're going to get the first bite of the apple. So if and we have this happen, like the person is not on Medicaid until they're 22 or now 26. They're living with mom and dad, right? They're on mom and dad's health insurance. And then at 26, they're going to go on Medicaid health insurance. And also they're getting some waiver that transportation waiver or something like that. And then tragically they die at 30. And so Medicaid's like, okay, well, for 4 years we paid health insurance. It's astounding how much their premiums are. It's about $1,500 to $2,000 a month. But if they had, like, let's say $150,000 in Social Security overpayment that they put into a Medicaid payback trust, and they have, well, that's too many years. That's too much money. So let's say they died after a year, and then Medicaid says, oh, we paid $50,000 of this person's benefits for the last year. And then Medicaid would get the first 50,000, and the other 50,000 in the trust would go to whoever, when the trust was created, it would probably be the parents or maybe siblings or something like that. So there's the possibility in a payback trust that not all of it's going to go to Medicaid. But if Medicaid was owed, let's say $280,000, and there was $100,000 in the trust when the person dies, Medicaid's getting all the money. Nobody else owes them the other $180,000. They're not coming after anybody else for that, but they're going to take the full one. They're going to take everything in the trust because Medicaid has paid $280,000 in benefits over the person's lifetime. So, but anyone can do a Medicaid payback, a regular Medicaid payback trust. And then I'm sensing the next slide is going to be my pooled trust slide. A pooled trust is different. It's less expensive to start a pooled trust because the trust exists. So you have to hire an attorney usually, and they do the paperwork, but they're just filling out, they're joining it, they're explaining it to you. And so, the startup of these things is going to be a couple $1,000s. They're way less than the other ones. And then, but now and the difference is these pooled trusts, they're nonprofits. So some of them, like Dayton has one, they are going to keep the money for their charity. That's the end of that. But other ones, you can say, okay, well, it can go to, you have some choices of charities of potentially, or you can leave it to go to family members or Medicaid. The whole thing is that when you're looking at Medicaid payback trust, Medicaid usually gets theirs first, but you can leave them to the charitable arm of the pooled trust. So like community fund, we have grants that we give out to people. For individuals, we have, like, some people get grants to pay for their emotional support animal or their service support animal to pay expenses like that, or dental work, or to put a ramp in their house that isn't otherwise covered, or some things like that. And then we also give grants to nonprofits. So that's what we use our trust for. So some people they would rather it went to that than to Medicaid, or we can pay back Medicaid, whatever you guys want. So, but the pooled Medicaid trust, that's how they work. They have designated charities that it can go to. That's an option. Now, the difference would be, like, let's say, again, let's come back to that individual who has not received Medicaid to date, but now has just come back with a large sum of money. Then you don't have to leave it to the pooled trust. You can say, I want it to go back to my parents if I die, because there's a likelihood that there's going to be money left in that trust. And you want it to go to the relatives. I don't feel like I'm explaining that very well, but hopefully that made sense. But that's how pooled trusts work. You have different options about who the money can go back to when the individual, the beneficiary, dies. You can have it be the family members, but it will only go to the family members after Medicaid has been paid. If you know you owe Medicaid a ton of money, you can just leave it to the pooled trust, and then Medicaid doesn't get paid back. The money all goes to the pooled trust, which has a charitable arm that they're supposed to use it for. All right, I think that made sense now. It made sense to me finally. I always figure if I don't understand it, You probably are kind of confused. All right. So community fund offers what we call a master trust, which is that wholly discretionary third-party trust. So you can create a pooled trust where the trustee is going to be community fund. I mean, it's actually Huntington, but the trust advisor is going to be community fund, and they're less expensive. Okay, I will come back to that. So on the pooled trust, you have the master trust, and whatever's left goes to your heirs. There's no Medicaid payback. We offer a pooled trust that has a Medicaid payback. We technically offer a roll-in trust, which is a type of pooled trust. Because of stable, we don't see these anymore very often. It would be for somebody who's just not eligible for stable, who's got a small amount coming in this month that's gonna, like, they've got $3,000. It's gonna make them ineligible for Medicaid, but next month they're getting a really big check. And so they'll do a pooled, a roll-in trust. Otherwise, people use the stable account for that now. And then we have partners who you can leave the money to, like Arc of Ohio is the only one around here any of us care about. Now, so there was a question about who pays the taxes on the gains. And that's right. So if I put money into the trust, I have $100,000 in the trust, it's invested. At the end of the year, it has made $5,000. Someone's going to pay taxes on that $5,000. So if it's a master trust and it is revocable, and mom and dad who signed the master trust are still alive, mom and dad owe are going to get a K-1 and pay taxes on that $5,000. If it's the child, then if mom and dad are dead, then the beneficiary would pay taxes on that. Now, to be clear, I'm not a tax person, but I do basically think this is right, which is that if you spent $5,000 in assets from the trust, then that's going to offset the increase. The same with the pooled trust. They don't get a K-1 on a pooled trust. It's different, but oftentimes we'll send you the tax paperwork. We can recommend accountants that other people have used. Some people use them every year to do the tax return. Other people have them do it the first time and then go, oh, I see what they're doing. And then they do it themselves. Because it's weird little forms you have to fill out. I hate taxes. So, but yes, somebody has to pay the taxes on any gains, and we send the paperwork out. So, and then the family, we have somebody who's called the designated advocate. They would be the person responsible for making sure that happens, because of course the tax is specific to individual people. All right, so those are the trusts that community fund offers, and not all pooled trusts offer the wholly discretionary third-party trust, but it is an option. It's not a good option if your goal is to have your child live in your home, because community fund does not own real estate. And so remember when I said, well, I'll tell you when it's a bad idea. If the goal is that they're going to live in the house, our trust is not the option for you. You would need to have a private special needs trust, a private wholly discretionary trust. All right, we can go on to the next slide. So, all right, so I'm going to answer the question. So generally speaking, so the question is there a special needs trust that we fund now? And generally the answer is probably not. So, and this also addresses one of the questions that I got about stable. So I'm going to use that to kind of side into this. Some people do want to fund this, they want to put money into a special needs trust now because they want to make sure it's funded. And if they were going to do that, I would recommend that they either do the master trust through community fund or some other wholly discretionary special needs trust. I would make it irrevocable. And you can do that with the community fund thing, or you can do it with the other trust if you're actually going to put money into it. But for the record, I don't actually recommend doing that. I would just make it irrevocable if I was going to put money into it. I don't think it's a good idea to fund them because once you've created that and you've made it irrevocable, it's taxed at a very high tax rate. So that's and if you're just trying to grow it, you're not going to spend anything down. So you're going to pay this massive tax rate on anything that grows that you would not pay if you just kept it in your own name. If it's if you think other people are going to contribute to it, you can use the stable account for that. Though you need to remember something. The stable account is not a wholly discretionary item. It is a payback vehicle, which means that if your child passes away over the age of 55, anything in a stable account, stable accounts do not allow you to make them payable or transfer on death, which means you regardless of how old your child is, when they pass away, if they have money in the stable account, you have to open a probate case to get that money. And if they're over the age of 55, Medicaid is entitled to notice, and I'm fairly certain they will assert a lien against anything that's in the stable account. If they're, I will say that my understanding from stable employees in the past is that stable will gladly and gleefully help you spend the money to pay for the funeral expenses and any outstanding expenses that are out there to bring down the stable account balance before you do notify them, before you run through probate. And so potentially there would be nothing left to pay back. But that's now when these accounts still have small amounts of money. We're starting to see accounts hitting $50, $60, $80,000 because stable's been around for a while. And so I don't think it's realistic that you could spend all that down that quickly. And then Medicaid would assert a lien. So if people are giving small amounts of money, I think stable's a great way to do it. But if you're talking about, you have relatives who want to give 10, 15, $20,000, you'd probably have to create an irrevocable trust and understand there will be tax consequences to that. Again, we generally don't super recommend funding trusts while you're still alive because you might need the money. So you might need it. And once you put it in that trust, you can't get it. It can only be used for the beneficiary's use, which is your child with special needs who's living with you and you're paying for their care at this point. So you don't really have a great need for it right now. So if you wanted to do something like community fund, I'd recommend you go on our website. There are all these documents. You do have to have an attorney assist you, and you have to select what's called the designated advocate. And that's the person who's going to request the money. It can be the person with the disability. That's not ideal for a lot of other reasons, but which we can go into later if you want to talk about them, but it can be. And we do it a lot. We have, especially when we have individuals with disabilities who are exceedingly high functioning or have no developmental or cognitive impairment, they want to be their beneficiaries, and they want to be their designated advocates, and that makes sense. But it just creates some weird catches because the trust won't reimburse them money directly because they might over-resource them. So, all right, if you want to go on to the next slide, I think we're getting to the, and then I'm not going to spend a lot of time on this, but you can take, you can set up automatic payments. There's all this stuff on the website about how to request money. And the whole thing is when they get a request for a distribution out of the trust, what they're looking for is we want to make sure that any payment that comes out doesn't negatively impact their benefits. That's our goal, to make sure that the benefits are maintained. So, all right. And then the next slide. All right. So here we go. Here we're going to talk about stable, and we're going to talk about stable, and I'm going to address some of the questions from last night too. All right. Or not last night, the other night. So stable account and special needs trusts work together amazingly. Also, stable accounts are now just part of how we do planning for individuals who are on Medicaid and SSI. Why? Because the thing about all of these special needs trusts, the catch that I haven't mentioned yet, because I don't need to as much anymore, is that you cannot currently use these trusts for the two most important things you want to spend it on. Food, which any day now that should change, and housing, which will not change anytime soon. And so you're like, hey, I'm leaving my kid all this money and I want them to live in a nicer home. I want them to live in a nicer apartment. I want them to have more. And to, be able to have, live, I don't know, a gluten-free diet with fresh raw vegetables. I have no idea. And you're like, that's going to be so much more expensive. Well, you can't use a special needs trust for those things. You could use the special needs trust money to buy a condo or a house. That's fine, but you can't use it to pay rent. You can't use it to pay the HOA fee. You can't use it to pay property taxes, gas and electric, water, trash. I don't know what else, but you can use it to pay cable and cell phone and phone and internet. You can use it to pay for clothes and furniture and those kinds of things. There are limitations on the Holy Discretionary Trust. But I can take $18,000 a year from my Holy Discretionary Trust or my payback trust and put it into a stable account. And I can use that $18,000 that was in my trust 5 minutes ago, and now I can use it to pay for food and housing. It's money laundering that's been allowed. It is literally legalized money laundering. There are a lot of things like this that Medicaid has. Like, hey, you can't use it here, but if you just put it into that account, then you can use it for any way you want. So stable accounts and special needs trusts work together. But here's the problem with all of these. So when your child passes away, as I said, in the pooled trusts, when you set it up, or in the Holy Discretionary Trusts, or in any of those trusts, when you created them, it should set up what happens to the money when your child passes away. If it's their money, if it was your child's money to start with, then it's going to first go to Medicaid, and then it can go to anyone else. That's true with stable also, except in stable, I'm going to have to go ahead and file probate. Those trusts, I don't have to file probate, but with stable, I have to open a probate case. And if my child is under the age of 55, Medicaid cannot assert a lien, but if it's over 55, they can and they will. A question was, if my child deposits their check in a stable account, do they get a state of Ohio tax deduction? And I'm going to say probably, actually. Yeah, that makes sense. I mean, again, it's only for what, $1,000 or $2,000 off their Ohio income tax. Ooh. But yeah, I don't know why they wouldn't. If I'm the parent and I'm the representative payee, or I have control of the stable account and I suddenly die, does the account get locked or tied up in probate? No, these are not your accounts. You might, no. The question is, the first question was, can I transfer money from I'm going to come back to what I was going to say. Can I transfer money from a special needs trust to a stable account and then to a Roth IRA? And no, you cannot do that. Because you can't get cash out of a stable account. So that's just not an allowable transfer. And a Roth IRA is not something that's from your employer. So it's immediately available asset, which would make you ineligible for benefits. So, but if you die and you're the rep payee or you control the account, it's not your account. So it's irrelevant that you've passed away. Now, if you're the rep payee, somebody else has to go and become the rep payee. But as soon as the death certificate's issued, honestly, probably before that, you can just schedule an appointment at Social Security. You can go to Social Security and take care of that. So nothing should be locked up like that. And the stable account, your child it's their account. So they can, if they have the means or they have someone else who can help them, they can contact stable and get the account reset. So that shouldn't be a problem. I missed the second chat thing or something about SSDI, but I didn't see it. Because the first one,
the one after the Roth, there was one, do you lose SSDI eligibility over $100,000 or just SSI? Currently receiving SSDI based on parents' SSDI.
Yeah, you never lose SSDI because remember what I said at the beginning, SSDI doesn't care how much money you have. You can have $1 million. You can only have $500,000 and 400 and something thousand in these accounts, but you could have $1 million total. So so that's not a concern at all. Somebody asked, now I can't answer the questions about if we get a check, do we have to put the check into our account and then how do we get the check in a stable account? And I got to tell you, I don't actually know. I work around stable, but I don't work with them. But I will say this, when you put the money into your child's regular checking account, as long as the money is out of their account by the end of the month in which they receive it, it wouldn't affect the $2,000 limit. And I don't think gifts, I'm not sure, but I've never actually had anyone have a problem with that. But what I would actually have them do, I mean, personally, is I'd deposit into my account and then I'd transfer it to the stable account that way. So that's what I would do for like birthday and Christmas gifts. That's not, just to avoid the confusion. So but there might be a way now with Stable to electronically deposit the check with photos, just like you can with other things. They're pretty advanced on how to do that stuff. So the other question, there's a big question about if I have a 401k at work, can I do the additional earnings contribution? And so remember here it says you can put $18,000 a year plus 14,580 if you earn amount from some employment. Yeah, you can still do that. I don't think there's any limit on that. I don't think that has anything to do with it. So yeah, and someone said Stable does let you mail in endorsed checks. There's a form for that. So you don't have to deposit it into your account and then send it up. You can just send it directly to Stable, which makes a lot of sense. So there's this able to work. And basically what it is like, let's say I have a child who works at a smaller company that offers a simple IRA or some 401k for their employees, or I work for Kroger and they have a pension. So that's different, but they have a 401k also. I can go to that. You as the parent or your child could go and advocate to them. Hey, a 401k is ultimately going to really, is ultimately going to it's going to be a problem in the long run that we have this money in a 401k. It's a potential problem. It isn't necessarily, but it probably is going to be like, especially if they lose their job, they have a very short time to get the money out. They're going to pay penalties and interest, and that's really annoying. But hey, listen, instead, employer, will you let my child contribute their wages from you instead of to a 401k? Can we do it to the able to work? Now it's a few steps that have to be made, but it is something that can be done, right? So that's an option that you have. But even if I have a 401k at work, and then to be clear, if I'm doing the able to work program, that my income dollars, instead of going to my company's 401k, are going to Stable. Yes, that is part of the 20. I'm really bad at math. $22,580 that I can put. No, 32. There we go. That's why I'm bad at math. $32,580 that I can put into my Stable account if I'm earning $14,000 a year plus the $18,000. All right. So that would count towards that. But if I have at work, I have a 401k and I'm putting my max into the 401k and I still want to put $32,000 into a Stable account, that's allowed. That doesn't care. They don't care about that. That's true for 403 and 403Bs and 457s. So there was another question that popped up, and that is, do you have to keep copies of all your receipts for your Stable account? You shouldn't, because you can't really spend it on things. It doesn't matter what you spend it on. The whole question is, the whole thing is that we're using the money from the Stable account for the individuals, for the beneficiary's use. And in that situation, they don't really care so much. I don't think they really care so much how you're spending it, unless the only thing would be if there's an allegation that you're not using it for their care, then it might blow up. But I've never seen that. I don't think there's any oversight for them to catch that. So I don't think that's relevant. There was another question that was too long for me to see from Kevin. I don't know what it said.
It says, in order to minimize Medicaid payback from funds from a Stable account, in the case of the death of the beneficiary, can a trustee just transfer an estimated money needed for a given year for items like housing and food from a special needs trust?
Well, actually, I even think I wouldn't even do it on a yearly basis. I would do it on a monthly basis. I would set up a recurring transfer from my wholly discretionary trust to the Stable account. On average, they're spending about $1,250 a month from the Stable for the housing and the food. I'd be transferring $1,250 or $1,300 a month from my wholly discretionary trust. And that way, if somebody passes away, I haven't bothered to put $18,000 in there and they pass away the next day and I lose all that. I've only put 1250. Also, that way, if somebody hacks or gets control of the stable account, because it's just a bank account without all those protections, actually, then they haven't lost it all. What we've seen is individuals who have mental health issues, who get manic, they get control of their stable account and they wipe it out. And so that's why we also say, yeah, I put small amounts in each month. The Holy Discretionary Trust shouldn't have any problem accessing all, doing these simple, smaller transfers. So, yeah. Let's see. We already talked about that. I think we talked about, disabled accounts or trusts allow dependents to be set up as beneficiaries or payable on death? No, they don't. And then is there, if you want to set up accounts, you, it says set up a traditional life insurance plan. That's what I don't understand that, but you can't name beneficiaries on stable accounts. And on the trust, you do. When you create the trust, you set up a beneficiary. So that is part of the process. So I think I answered all the questions from the other day. They don't get locked.
Yeah, I think you did catch them all.
Okay. All right. All right. I think I'm updated on the chat too. Have I missed anybody on the chat? Let us know that I missed you, which is possible. And then otherwise we're going to go on to the next slide. But I do want to say before we leave this, to me, stable is like a necessary thing to go along with the special needs trust. They complement each other so amazingly well. And they give you a much greater range. So if you put your money into the Holy Discretionary Trust, you've guaranteed it's protected for the benefit of your next generation and for the individual with a disability, then the trustee can have control over the stable account and be putting money in there bit by bit to pay for the things the trust can't pay for. And about the receipts, I don't believe you need to keep receipts from spending money from a stable account or an able account. I don't think that you do. I've never heard of that. Because again, there's no oversight. There's nobody who's checking it. The penalty on stable accounts for improper use of money is that you would have to pay income tax on the earnings on the interest, which if you're not keeping that much money in it, it's nothing anyway. So I've never seen Social Security go after a stable account. So, but well, there is no tax purposes for a stable. I don't. So the only tax purposes that I understand that deal with a stable account are that I get a deduction when I put money in, and stable accounts, the interest grows tax-free, just like a 529 account. So there is no tax issue relating to the earnings on a stable account because they're like a 529. And the only way it would be an issue is if Social Security did an investigation on the belief that someone was improperly using the funds. I don't think they do that. I don't think they even have a mechanism set up to do that. I don't know what that means. Keynotes to a third-party discretionary trust. I don't know what that means. I'm not sure what you mean by that. So if you can clarify that, that'd be great. But we can go on to the next slide. But I still do say that you really need to work on those things together. So, and the thing about the reason you can't use a stable account as an estate planning tool is because you can only put this limited amount each year. You'd also lose SSI if you had over $100,000, which is annoying. Now, this disability age is constantly changing, so I wouldn't stress about that. They're upping that. They're talking about moving it to 45 and then probably getting rid of it. But also the other big concern I have is obviously the payback on the beneficiary, the death of the beneficiary. So it's not the greatest. It's not a estate planning tool. It's a living day-to-day tool. That to me is the big difference between the two things. All right, and then we're going to go on to the next slide.
There is a question out there. It says, I have a special needs trust for my daughter. Do I open a stable account? Whoops, it jumped. Hold on. Do I open a stable account now, or can the person in charge of the trust do it upon my death?
You can do it. Well, the stable account has nothing to do with the person in charge of the trust. That's not how that works. Either the beneficiary has to do it a parent when the child's under 18, or it has to be a guardian or someone with a power of attorney. So that the trustee wouldn't have power to do it. So they wouldn't have power unless they were named, unless they were the guardian or the power of attorney of the individual. But now I can just sit there with a person with a disability with me and set it up then. So that's something to think about. There was another question that just popped up about, oh, what was it? It was,
It says, please confirm Medicaid payback on death of beneficiary only if over 55 one passes, question mark.
that is only as relates to items going through probate. So that impacts a stable account. The Medicaid payback trusts, that is not true because they don't go through probate. A Medicaid payback trust, all of whatever Medicaid has paid out to date will be paid back. So the over 55 is only what relating to items going through probate, and special needs trusts don't go through probate. So stable and your child's regular checking account. Anything else, that's not true. And so, and then there was a question to explain the wholly discretionary third-party trust. And what we mean, a wholly discretionary trust is mom and dad's, grandma and grandpa's, siblings, anybody but the beneficiary with the special needs, It cannot be their money, but it can be anybody else. They're the ones who create, so everybody else can create this wholly discretionary trust. And that's why the third party is the one who funded it, not the beneficiary. The beneficiary is the first party. So the parents, usually it's the parents, the grandparents, they fund the trust with their money. They're the third party. And then because it's mom and dad's or grandma and grandpa's money, it's never the beneficiary's money. When they pass away, when the beneficiary passes away, when the child with the special needs passes away, whatever money is left in the trust, if there is any in the wholly discretionary trust, will go to mom and dad or grandma and grandpa's other heirs, or, children, grandchildren, charity of their choice. That's how the wholly discretionary trust works. In actual action, all these the trusts all work the same. What they can spend the money on, it doesn't matter what kind of trust it is. The type of trust impacts what happens when the person passes away. So I hope that, if you still need clarification, I'm happy to give more. So some other things that you need to think about, like I said, if you want to leave your the family home to your child, and they're going to live there after you pass away with the IO waiver and, caregivers and such, that's fine. But then you're going to need to make sure you address that home in a trust or some other mechanism. You have to have some plan in place for that. And a pooled trust is not the option. Guardianship, I know you've talked about this already and it's coming up, but, and we talked about the residency thing, but easy ways to avoid guardianship are through powers of attorney, a living will, and a healthcare power of attorney. And then DNRs, those are things that come up later in Ohio. And there's an organization called Planned Lifetime Assistance Network, which is kind of like, it's a nonprofit here in Hamilton. It's in Hamilton, Warren, Butler, Claremont, but they'll go a little bit further up to Montgomery sometimes for some stuff. But they're a nonprofit that kind of answers the questions, who will take care of my relative when I'm passed away? So like my brother, we have him enrolled in Plan. And so he does some activities with them. And so we can, if my parents passed away, we could pay them to kind of check in on him in addition to other services that he would be eligible for, while my sister and I are still working and not able to do that. So that's an option out there. And so then in the chat, somebody asked me, do I recommend that, like, if an uncle wants to leave money to somebody, did I say they should set up their own special needs trust? They can. The whole thing about that is, if the uncle and the parents and everyone agrees what's going to happen to the money once the child with the special needs passes away, and it's all going to go to the same heirs, it seems like a lot of effort to have multiple trusts when all the money is going to end up in the same space. And And then when you have multiple special needs trusts set up, which I have clients who do have those, oddly, then it's a question of like, which one do we take the money out? Which seems strange, but it's relevant, right? Because if I'm the one who's in charge and I'm going to get the one left over in trust A, I'm going to take the money out of trust B because it doesn't benefit me. But what we see sometimes is we have trusts that are weird that are out there, and it's just the money's going to fall off a cliff. So then we spend that one down first. So you can have multiple trusts, but it gets into some weird stuff afterwards of like, why did you take the money out of that trust but not this trust? I would have gotten money if you hadn't done that. And so that does concern me that you could have some bad feelings later on. You can have some bad feelings later on, but the law about special needs trust is such that the trustee's goal is just to spend the money down. There's no real limitation on which one they spend it from. So that would be my only concern. But we see families do separate trusts. All right, we can go on to the next slide, which I think we're getting into like information about how to reach me. All right, there you go. That's me. You are welcome to email me. That's our website and the general information for our main office. So our main office is outside of Cleveland, but it's okay. We do the whole state. And they're nice. Trust me. I've worked with them up there. They're nice people. I'm not crazy about Cleveland, but whatever. And then that's my contact information. You're welcome to email me or call me. If I haven't responded to you in 48 hours, just send me the email again. I get, and this is true. I on one email account, I have 5,000 unread emails. I mean, I know I get a lot of emails in a day, and that's just one account. And I actively unsubscribe from stuff all the time. It doesn't help. It doesn't. I swear I just want to take a week's vacation and just get to zero. That's my goal one day. It's never gonna happen. It's a goal. So then the question came up, what about this uncle who wants to leave money to my relative, to my child? Well, again, I would have a conversation with the uncle. What do you want to happen to this money afterwards? If he wants the money to go where you want your money to go, then I think you should create one singular wholly discretionary trust, and you make it irrevocable so that if uncle dies first, the money that goes in is clearly protected for your child and you can't take it out. That protects what uncle's doing. And then, and there's no money in it right now, so it's not paying extra taxes, so it's not a big deal. It's fine to do that and then you leave your money to the same trust, because the expense is in creating the wholly discretionary trust, or in signing up with the joint, or the community fund one is in opening the trust. So if you guys can all join in the same trust, you're golden. And technically only one person has to be the grantor of the trust. Everyone else can just add their money to that same trust. There's no limitation, except the only person who cannot add money to a wholly discretionary trust is the beneficiary. Everybody else can I can add money to your child's trust. No offense, I'm not going to, but I could. Anybody can, but it's only the child who has the disability. They're the only one who's not able to do that. So Patty has the handouts and she has them on her binder. She'll tell you all about the live binder. So
yeah, we'll post a link to how to get to them. And then there was one that was sent, and I don't think it went that you could see it. There's we are the parents and guardians. Should we file and have our children as guardian? I think you covered that early on. But that was a question that was out there too.
yeah, I would just have it in a power of attorney or in the will. You don't want to add everybody to, you don't want to have, the court doesn't want 55 guardians. And if you're still active as guardians, you just need to you just need to have a document to make it clear you want them to be added on. What I will say is that, when tragedy strikes and one of the parents passes away, I think that's a good time to ask one of your kids to now be co-guardian with you. So there's a good transition and they can bail while you're still alive, and you can go on to the next person if they don't like it. So, but at this, the court's not gonna, I don't think any court's gonna allow 3 or 4 guardians. Today, for the record, this is kind of funny. I had 2 guardianships hearings today. I was in Warren County Court all day. This was my 3rd trip to Warren County today. I have not been to Warren County this many times in the last 6 months. But and the court was lovely. It was, I mean, yeah. So it was, and the magistrate was great about guardianship and all that stuff. But they still don't want 3 guardians because that's a lot. Do we have any other questions? You can chat.
Um,
You can unmute.
I do not see any other questions. If we didn't get your question, let us know. I'm trying to scan through them just to be sure. And just to be clear too, that you talked about the revocable, the wholly discretionary third party. Does that include like a home being as in a trust, or is that a different trust?
So that's good. So if I have a house, so sometimes I keep the house in a standard revocable living trust that becomes irrevocable when you die. And sometimes I put it in the wholly discretionary trust. I can do either. Personally, I like it in a separate revocable living trust because I just do. But I what I do when I do them is I say, okay, here it's in the revocable living trust, and I keep a lot of cash in the revocable living trust, which becomes irrevocable, just to pay for the house. And then if they run out of cash or there's something happens, they have the ability to move the house into the wholly discretionary trust. And I have language in the wholly discretionary trust if it owns a house. I just don't like, I don't like the wholly discretionary trust to own it, the house, because you have plans that they're going to live there after you pass away, but then things happen and that doesn't really work out, or the house needs a lot of repairs and we can't maintain it, and we don't want your child with the disability to be paying the trust their income to pay for repairs, because that gets to be the end of it gets weird. So I like them to be separate. I feel like it's not easier, but it's cleaner. And I'm all about cleaner when I'm dealing with Medicaid. So, but it's that's the attorney, when they set it up, they'll kind of explain it to you what their process is, and what their reasoning is. And so, and this is just, I'm going to real quick, because I got you for another second. I'm going to give you, when you're meeting with an attorney, and I always say that, and I mean this, you're hiring them. And if you don't feel comfortable with them, run away. Don't just walk away, run away. If you don't, because if you, and I've had people pay an attorney and then they come to me and they go, yeah, I didn't really trust, I don't feel good about it. I'm like, well, then why'd you stay with them? And then you look at it and you go, yeah, you were right to not feel good about it. We got a problem. And then you should ask them some questions. Ask them to tell you the difference between SSI and SSDI. If they can't do that, run away. Ask them to talk to you about the waivers. And if they can only talk to you about long-term care and assisted waivers, they're elder law attorneys, and that's a great field, but they don't necessarily know anything about, they need to know about the IO, the level 1, the health, they need to know all that stuff. And if they don't know the vocabulary of the disabled, then they are not good choices for this. And so there was a question like, how do my assets get from my money market fund into my trust? And that is through your revocable living trust or your will, or if you have already created a wholly discretionary trust and you've got its own tax ID, you can name that trust the beneficiary of your money market, just like any other beneficiary you name, right? Like you can name, my sister Susie gets 10% and Bobby gets 28 and this kid gets that. You can, this is where I can get, and then you put the rest of the money into the wholly discretionary special needs trust for the benefit of so-and-so, and you can have the tax ID, which makes it easier. I think your first step for looking for an attorney is National Association of Elder Law Attorneys, NAELA.org. They have a big find attorneys. They also have, there's the Special Needs Alliance. That's another group of attorneys. These are all people who do that. You can, those are good starting points. And now obviously NALA, they're elder law attorneys, but some of them do special needs. So, and a lot of most of them do that. But that's why we want to ask them, like, tell me about the waivers, because if they don't know about the IO and the self and that, they're not a good choice. They don't know what they're talking about. So, I mean, they don't know what they might not be the best bets. Like, there's an attorney, he's my attorney, and I think he's a great attorney, but he does special needs trust. But I'm like, you don't have anyone in your life who has special needs. You don't. I don't think he gives very holistic advice, right? Because I don't think he thinks about it like I do, and so I never recommend him to anybody because he's always naming the sibling as the trustee, and I'm like, why? I mean, there's no way that's always the best choice. So I think it's important that you try a few people on, ask them questions. Most of them should meet with you for like 15, 20 minutes, 30 minutes, just to get an idea what you feel for them. And you can just say, I'm interviewing attorneys. I want to get an idea of your approach. And if they won't do that, then somebody else will. So.
There, I just took down I stopped share on. I'm going to stop the recording here in case somebody wants to unmute just before we let you go, Laura. But let me just stop the recording real quick. Thank you for coming and speaking to us and to all those online and there in the room. But one second. Okay.